This will be the phase of the attorneys representing private clients may provide their comments regarding the proposed formal notice of intent. Each attorney will be limited to 10 minutes. Please state your name and address when you come present and the name of the clients that you are representing before providing your comments. So, Mr. Uhlfelder, I think you're first.
Good afternoon. My name is Daniel Uhlfelder. I'm a resident of Walton County. I'm a second-generation Floridian. I represent the Florida Beaches for All, which is a 501c4, which its purpose is to preserve customary use. I currently reside at 93 Sandy Creek Drive. I own property.
You have to use your outside voice.
Yeah.
Oh, okay. Hello? Is that better?
That's much better. You get closer.
Is that better? I reside at 93 Sandy Creek Drive. I have a commercial property in Grayton Beach. Our family has owned multiple properties in this county going back to the early 90s. Our group, Florida Beaches for All, supports the passage of customary and reaffirmation of customary use ordinance. We have certain issues with the manner in which the law that was passed that is being implemented or procedures being used today, and we are not waiving any of those rights with regard to any potential challenges that may occur to that legislation. I think there has been a question about why are we here today? We are here today because Walton County was targeted by a number of people in order to bring us to have to do this again. In 2016, Walton County passed an ordinance. I have a copy here with me. This ordinance was fine and dandy. There was no reason, unfortunately, we are here again today to go through a lot of the same procedure. This ordinance was passed in effect 2017. Certain individuals with funds and wherewithal decided they were not happy with that. So they went to the legislature. In January 2018, through public records, this is an email, January 9th, 2018, from the firm Hopping Green and Sams, who was here as well representing certain owners. And in that email it says, since the Walton County ordinance was adopted in mid-year 2016, can't we just say, quote, this section shall not apply to an ordinance adopted and effected on or before January 2nd, 2016, end quotes. That would protect Volusia and St. John's, but address the overreaching Walton ordinance. After that, there was an email sent from a resident of Walton County. This is a public records. That resident, according to his address, lives at 756 Blue Mountain Road, Santa Rosa Beach, Florida, 32459. His first name is Mike. I will leave it at that. According to the email to the Senate sponsor, I had just come back from an 18-hour trip to Qatar to watch the committee hearing via internet and was stunned by the inaccurate and misleading comments by David Theriak and Tony Anderson of Walton County BCC. He goes on and on complaining. I asked him if he's going to be here. He banned me from his Twitter account, so I don't think he will be. But this former governor of Arkansas said, what beachfront owners object to is illegal taking of taxed and titled property without compensation or even consideration. The issue is that there's two counties, and I've got the ordinance from St. John's with me as well. The St. John's ordinance was passed in March of 2007. There's no difference between this ordinance and the Walton County ordinance. The difference was that St. John's didn't have the lobbyists, didn't have the people to come and fund this process. This process is unnecessary. It's been explained in the Nassau County ordinance as cumbersome, expensive, unnecessary, but that's why we're here. And I know questions are, why are we here? Why do we look back? Because past is prologue. And Florida Beaches for All is here to say that we support and hope you vote today, but we know that this is not the end. This is just, unfortunately, a process that's going to continue because the army of lawyers, and they're very good lawyers, and their clients are going to continue to fight this. And we want you all to know that Florida Beaches for All will stand by you If we have to be in Washington, D.C. in 3 years arguing for the U.S. Supreme Court and protecting our beaches, we will stand by you because it's that important to us. In the legal issues, I think the elements were met in 2016 with the ordinance. The evidence was presented, it was challenged, we've gone through it again today. The elements for customary use, I believe, have been met. I believe that it was met in 2016. We're simply here because of certain influential people who were able to try to come back and take another shot at the apple. They want to take another shot today. You'll hear argument today from very well-versed counsel about why the elements haven't been met, this and that and there, but they had that opportunity. They're just trying, this really is just a process to try to drag this out, break you down. The last time we were here, September, we had 900 people. This time, we don't have as many people. Well, we had to come back because this is going to be a test of wills. And I think what we need to be able to show as a community that the use of our beach is that important to stand up to. If you look at the Nassau County ordinance, which I've also brought with me, which I think lays out some of what I think you all should consider. One of the reasons it enacted this ordinance is because it is nearly impossible for a beachgoer to know where the mean high water line on any given day, since that line is dynamic, arrived at using a mathematical average of the movement of the high water line over a constant rolling period of time. They are arguing the mean high water line, this is our boundary line. In order to assert that you own a piece of property, you need to show that person where the line is. I've been out to a couple of people's properties. I've been to Vizcaya and asked for where the line is and not got an answer. So if they're going to want to say, this is our property, show me where the line is. They can't. That's the point of the Tony Roma case where it talks about, we're not talking about a backyard, we're not talking about somebody's backyard. Give me a break. We all know this is not somebody's backyard. The Tony Roma case, as Mr. Theriak pointed out, emphasized this is a Florida Supreme Court case from 1974. It hasn't been overturned, it hasn't been rescinded, and it specifically said is that the beaches of Florida are of such a character as to use and potential development as to require separate consideration from other lands with respect to the elements and consequences of title. This is not an issue about we're challenging your title. Clearly there are big problems with the title. Blue Mountain Beach has been a quiet title fiasco, going back years where they just changed the title, go in 2 months, but that's not what we're talking about. The Florida Supreme Court, which is still good law, and which you all have complete authority to follow, and you did in 2016, says that the sandy beach portions of the beach are of no use for farming, grazing, timber production, or residency, the traditional uses of land, but has served as a thoroughfare and haven for fishermen and bathers, as well as a place of recreation for the public. The interest and rights of the public to the full use of the beaches should be protected. That's the Florida Supreme Court, 1974. 2 years after I was born, it still hasn't been changed, and you all have full authority to do what you're doing, and I still believe, and I know you had authority in 2016, but the money there was too much money on the other side to get it through. So that's the issue. Also, the Nassau County ordinance recognized that they've got their ordinance passed. I hope, from what I've heard in that county, that there has not been a lot of challenges. We believe that it is undisputed that the evidence that's been presented was presented 2 years ago, that the elements of customary use have been met. Unfortunately, as you're going to hear all sorts of, in the next hour, good arguments about this. Well, it's uninterrupted. Somebody was on my beach here. I mean, these beaches have been uninterrupted use for thousands of years. This is just, it's all about one thing. I mean, this is it. This is all this is about. That's all this is about. The dollar bill. It's not about private property rights. These people aren't using the beaches. Every beach Mr. Hackmeyer, got to know him. I got to know a lot of people in this, and we've had some spirited discussions, but I've never been to one of these beaches where it's an issue of it's being too crowded. This is about a monetary play to try to privatize and take these beaches. We stand behind what you do. You did it right in 2016. We're going to, Florida Beaches for All is a group of private citizens that have pulled together and said, this is our lifeblood. The beaches and the sand of Florida. I'm a second generation Floridian. I've been on every beach in this state, and the beaches, I wear bulletproof pajamas to bed because people are coming after me this. I'm not going away. And I hope you don't go away. I know, Mr. Andrew Jones, you're not going away in whatever position you are. I want you all just to know that the amount of outpouring of just support that I've felt since I went on that beach 3 months ago has been enormous. And the people, we may not have all the lawyers. I mean, I may be the craziest lawyer to take this case or help this, but we got the people and we are right, and we want you to vote 5-0 and send a message to the money and to the people that customary use is in Walton County forever. Thank you.
Thank you. Go ahead, Will.
Thank you, Chairman, Commissioners. My name is Will Dunaway, D-U-N-A-W-A-Y, law firm Clark Partington with offices in Grayton Beach. My firm represents over 50 beachfront property owners who object to this board's attempt to establish a right of custom for the public to use a private property. Mr. Chairman, you asked that we name our clients. I, on August the 31st, submitted 39 written objection letters. I followed those with 5 more the next week, and then I have 20 more with me here today. I'd ask that they be admitted into evidence.
So moved.
Mr. Chairman, I'd further, other than their objections to the proceedings and to the establishment of customary use on their private property, I'd also like to object to the admission of the testimony from the September hearing. It was very clear at that hearing when this body talked to that issue and indicated that because of the lack of notice, you would not be accepting evidence, and therefore that testimony was not evidence. I would also like to state for the record that we object to the affidavits being admitted into evidence as they are hearsay. Commissioners, when Mr. Matthews and I appeared before this board back in August of 28 to request this time, we were looking for an opportunity to help this process together. You graciously allowed that we would have the 10 minutes each for the 6 attorneys, and we promised you in exchange that we would not repeat ourselves. Therefore, to that end, we've organized our presentation as follows. I'm providing this overview and the briefest of primers on the law with regards to customary use in Florida, much you have heard earlier today. Mr. Dana Matthews will next discuss the county's history of approved land use patterns and how that approval by this board has interrupted those prior uses of patterns in South Walton in private ownership. Mr. Kent Safford will discuss the history of tourism, the carrying capacities of the beaches of South Walton, and this board's role in creating the present conflict. Mr. David Pleat will then review the recent legislation, that is HB 631, and the statutory processes it lays out for notice, this hearing, and any circuit court action that you might initiate and that private property owners might have to defend against. Mr. David Smoker will then explain why the process as outlined in HB 631 was needed here in Walton County, because, as Tonoroma and the laws of this state indicate, only a neutral, unbiased decision maker, i.e. a circuit judge, may ensure the due process needed to adjudicate the constitutional rights of private property owners as followed. And finally, Ms. Mary Grace Rahm will conclude with a brief review of this board's history of using taxpayer dollars in purchasing beachfront parcels for public use and allocation of that to vendors. Commissioners, the doctrine of customary use, as you have heard, is an unusual doctrine in the law because it allows non-owners to acquire a right to use a particular piece of private property for a particular custom or practice upon proving certain rights. In Florida, as you have heard, that doctrine comes from the 1974 case of Daytona Beach versus Tonoroma. There is a very good reason why customary use has not been established on other areas of beaches in Florida outside of Daytona Beach, because Daytona Beach is different, and Daytona Beach is not Walton County. And this is 2018 and not 1974. Your own expert, Dr. Miller, this morning recognized this point. He told you that the use of the public was interrupted in the 70s, And you are being now asked to establish customary use in 2018, not the 1970s. Things were different in the 1970s, as they were different in the 1980s and earlier times. In Tonaroma, the case went before the Supreme Court. There, a private property owner, the owner of that beach pier, and wanted to build that tower. And on his private property, he asked for permission, a permit to build that tower, and he was denied. And the reason he was denied is because the person down the way who already had a tower and didn't want him to build a competing tower objected and said the public had obtained the right to use that property by a prescriptive easement. And the case was briefed as a prescriptive easement case all the way to the Supreme Court. And the Supreme Court found that a prescriptive easement could not be held in this case and could not be found because the use of the property was not adverse, it was not hostile, it was with the invitation and with the permission of the property owner. And the Supreme Court case then found that the public could use it because of a custom, because there was consent, because the property had been used anciently, reasonably, without interruption, and free from dispute. In that case, based on the facts of the area in Daytona, we know that they had speedways on the beach. We know the pattern of use in Daytona. That is not the pattern of use in South Walton County. The use in South Walton County is a different use than was in Daytona. Only by proving all four elements of a customary use can you find that such a use, or that can a court find that such a use has been established on the beaches of Walton County. And it is important to note, despite what has been talked about, there has never been a finding of customary use made by a court of competent jurisdiction that customary use is established in any of the beaches in Walton County. And this board itself so affirmed that indication when you had in your beach activities ordinance for many years at section 2252 that there was no determination one way or the other of whether the beaches had been used by custom. That had been in your ordinance for many, many years. I quote from HB 631, "There is no presumption regarding the existence of a recreational customary use with respect to any parcel of property, and the government entity has the burden of proof to show that recreational customary use exists." This board has recognized it. Your predecessors have recognized that customary use has not been established. You are seeking, if you are moving forward today, to establish it for the first time, given the facts that are presented to you today in 2018. Any of the four elements of customary use, if any of them are defeated, the concept defeats and it fails. The county must prove that, as I indicated, each of the four elements. It is important to contrast your situation in South Walton with those of other counties. We've talked about Daytona Beach. The other county to look at is Escambia County. In Escambia County, the citizens of Escambia County will be voting next week to retain their beach. They own it, all of it. In Walton County, the pattern of progression, as your expert has already told you, is that you sold it. It went out of government land patents into the private property, and then it was subdivided and approved by previous previous editions of the Board of County Commissioners. It is also important, Commissioners, to remember that the western portion of Walton County has already had established on it an erosion control line. As you well know, the establishment of an erosion control line under the state law indicates that all property seaward of the erosion control line is public. That's the indication there from a picture on spring break on western Walton County. The erosion control line is about right there at the back end of that group. That's the difference between establishing an erosion control line for a public beach and not having an erosion control line, but 4.5 miles of your western county have public beach. As Dr. Miller has already explained, the government land patents, this one in particular is from 1949, established the disposition of much of the property in South Walton County. This government land patent from 1949 clearly indicates that the land was platted all the way to the mean high water line. That block 38 was then later sold out of that government land patent out of the United States into private property, and then a predecessor of you sitting as the Board of County Commissioners approved this plat in 1955, approving it down to the mean high water line, reserving the access easements, and as someone has told you earlier, could have reserved others. That's the action of this county. Mr. Matthews is next.
Okay, thank you.
Good afternoon, Commissioners. Dana Matthews, M-A-T-T-H-E-W-S. I'm a resident of South Walton, have been since 1984. I represent Seascape Resort, Sandestin Resort, another company called DBLH. It's a Deerfield or Deer Lake lot on the beach. And I previously delivered to the county through Ms. Noyes letters on who I represent, objecting to this CU process, but in hopes that maybe you will exclude my client's properties today from whatever action you take. If you choose to vote in favor of CU, I would like to hand this to the chairman so you can remember to have the, quote, the right parcel IDs for my client's property to exclude.
Hand them to the clerk, please.
Thank you, Mr. Chairman. I've been practicing law for 37 years. I'm a property rights lawyer. I've appeared in front of this board and its predecessor boards for many, many years. And I do have and being in South Walton, well, actually I moved here in '68. My daddy was in the Air Force. We moved to Fort Walton when I was 12. So I've had a kind of a unique experience, maybe not unique, but a different perspective than some of the people who have spoken to you today. And in particular, I want to talk to you about development patterns. I heard from all the speakers today. Everybody's got very strong, passionate views on this. I do not envy being in your situation. I get it. But I think there's some things that you need to consider from a development pattern standpoint that is going to clearly impact your abilities in court, but more importantly, it ought to tug at your heart a little bit and say, is this really the right thing to do? You know, Florida became a state in 1845, and when you go to the, this is, what was this one say, 1849? This is the 1849 map, and it shows you clearly that Walton County, this particular area, which is consistent with the rest of the state, this is one of Dr. Miller's as well, all the property goes down to the water line on the beach. Next one, Steve. That red box was just to show you that here's Gulf Pines and here's a particular subdivision that one of your prior boards approved, and all the lots butt up to the water. And it was approved, it was dedicated, approved, and signed by every county commissioner at the time. Next slide. That just gives you a visual if you know where Gulf Pines is across from Sandestin area. Next. This is from 1960, and this shows the eastern end. That red area, the box, is right next to the Deer Lake, State Park right now today. Go ahead, next. That's the lot in question, and again, down to the mean high water line. If you look all the way down there, you're going to see, and this is a typical pattern of what's happened in South Walton. Not your fault, this is just the way it is. Go ahead, next. This shows you Sea Highland. Actually, I think this was one that was previously shown to you by Dr. Miller which I found interesting. He acknowledged to you there was over 50 plats that he looked at all on that 26 miles of beach. He showed you only 3 where the property was actually dedicated, the beach was dedicated to the public by the developer and accepted by the county and platted that way. This was one of them. He didn't show you the other 47 plats because that's what all these government patents, the ones that Mr. Dunaway showed you, the ones that Dr. Miller showed you, the bottom line is the federal government took title to this property. They decided to create these patents. They decided in Walton County, for whatever reason, to create ownership to the mean high water line. That's what they did. So when property owners and developers over the years came to the county commission for 50-something plats over a 40, 50-year period, they were the ones that owned the mean high water line, and they said, this is what we want to do. This is how many lots. Here's our public access. Here's no public access. We're keeping it for our owners. Whatever the situation was, and every prior county commission approved all these plats. Now all of a sudden, fast forward 40 years later, you can imagine why some of these property owners who've appeared before you today are a little bit upset about government taking their property without compensation, because the pattern of development over all these years, not you guys' fault sitting up here today, that's what's happened. That's how it's developed. Now let me shift gears. Go ahead, Steve. That's another area at Kareem, which is on the, as you know, going from Sandestin down toward Edgewater. Again on the beach, all the lots mean high water line. Next, Old Florida Beach, same thing. Next, that just shows, all right, property taxes, real quick. I'm not going to belabor this. Y'all know property taxes are higher on beachfront parcels as opposed to non-beachfront parcels. But this is an example for you in Beach Highlands. You see the red box, that's the house across the street from the beach. It's actually bigger, larger, more square feet, newer. It pays about $5,500 a year in property taxes. This is from last year. Go ahead, right across. See that box right across? That's the beachfront parcel. They pay $21,000. That's a typical example of what's going on all up and down. Again, not your fault. Y'all don't tax the properties. Property appraisers does it. They do it based on value. Why do they do it based on value? Because that's what the state legislature says to do in Florida statutes. Why do the people pay more for beach property owner? Because it's private and they own to the mean high water line. Again, not your fault. Pattern of development. This is what's happened over the last 40 years. Shift gears. That is, give you an idea of the properties along Sandestin, beachfront. My client's property's there, but I want to use this as an example. Y'all know that before there was a Rosemary and an Alice Beach and a Seacrest Beach and all that area down there, watercolors north and south, the area from Topsail and mainly Sandestin west, we call it Miramar, developed. 1976. DRI, y'all heard of this, y'all heard me a bunch of times talk to you about Sandestin and the DRI. This 2,250 acres. This is a private property. I mean, they own the bay, they own the Gulf, they own it all. It's a boundary. Y'all seen that in all these different hearings we had. This resort was created as a mixed-use resort so that not only owners would own, but there would be commercial activities, there would be guests, there would be renters, and it was the incentive for the different developers over the time to create amenities that were beautiful, to bring people down here from other parts of the country to stay in the resort and to use those amenities and hopefully go out and spend money in the community as they do with all the other different resources and the businesses that we have in South Walton. This was a classic example. So you got Sandestin, you have next to it, you got Hidden Dunes, you got Mainsail, you got Edgewater, you go down to Seascape, that's 2,000 feet of beach there. All these resorts, and including the ones on the eastern side of 30A, were developed and created for their owners, their guests, and these developers and their condominium associations and their resort, their master associations have security, have controlled access, where their owners and guests are safe. They haven't kicked people off the beach for walking along their beachfront down the beach. If they try to come up into the beach and into the dunes and to park themselves, not respecting private property, they are asked to leave. But we haven't had an issue with people walking along the beaches. I think we have, one of the speakers said it pretty classically, is that how did we get here? I have my own theory, but it's not going to do any good, and I don't have enough time to tell it. But I do have enough time to say this. Where you're at right now, a number of people on this side of the room are asking you to declare customary use. They're asking you to declare it on the beaches. Then somebody says the dry sands. I'm not sure, but I think from Dr. Miller's testimony and from his slides, it looks like it's from wherever the vegetation is to the mean high water line. I've heard toe of the dune to the mean high water line. But the bottom line is I've heard it's all 26 miles in that kind of a site dislocation. I would suggest to you that the area from Sandestin west to the county line is inappropriate. Will Dunaway told you, you got the ECL. The public already has the right to do it. None of those property owners are going to be getting involved in litigation with the county if you leave them alone. But if you now decide that the ECL line wasn't good enough and you want to go from that line up to the toe of the dune, then you're asking them to get into litigation, totally unnecessary. You can either choose to adopt the CU as being proposed, 26 miles, toe of the dune to the water. You know then you have to file a lawsuit. You know all these people are going to be jumping into the lawsuit. You're going to spend hundreds of thousands of dollars, 10 years, U.S. Supreme Court, for what? Or you can not pass CU, not get sued, or be in litigation, use your money to buy beach access parcels, which y'all have done a great job with TDC dollars the last 2 or 3 years. 35% of the county beaches are now owned by the county. Save your money and work it the way so that the public has access there, but not over private property rights. Thank you.
Thank you. Next up, I guess, is Ken.
All right, thank you, Mr. Chairman. Again, my name is Kent Seyfried with the law firm of Hopping, Green, and Sams in Tallahassee. On behalf of approximately 50 different landowners, and like the prior attorneys, I have submitted an objection letter with the parcel ID numbers of my clients asking to be excluded from the customary use declaration to the extent the commission decides to do that. I'm here to talk a little bit about tourism. I echo all the comments my colleagues make, and I adopt them in my presentation so that we don't have to reassess those and restate those. I'm here to talk a little bit about tourism. Why are we here? What is this really about? What is customary use declaration on all the beaches about? What's the real cause of the problem? The real cause is use conflicts between people wanting to use the beach and landowners owning the beach. That's the cause. But what's causing that? Why are we here? We weren't here 10 years ago on customary use. We weren't here 20 years ago, 30 years ago. So why is it we're here? Do you think all of a sudden beachfront landowners woke up one morning and said, I have these rights to exclude and I'm going to use them today? That's not the case. Do you think it's the residents of Walton County starting to use the beaches inappropriately one day? It's not the case. What's changed is tourism. What's changed is the number of people that are in Walton County, not the residents and not the landowners, not the people moving here to live permanently as opposed to visiting, but it's tourism. It's the numbers. How many tourists do you think were here in 2000? According to the TDC stats, 1.2 million tourists visited in 2000. Any use conflicts? Any calls to the sheriff to remove people that were disrespecting property from the beach in 2000? Submit not. Maybe your one-off extreme example. You always have your extreme examples on one issue or the other. 2009, 2.2 million visitors approximately, almost double. Bunch of use conflicts then? People being dragged off the beach in handcuffs or anything of that nature? No. No, it's only happened recently, in the recent years. And let's look at the tourism numbers. 2017, 4 million visitors. Almost quadrupled in 18 years. Now, do you think the infrastructure has quadrupled in 18 years? Do you think the beach has grown 4 times the size in 18 years? It hasn't. We're getting to the point now where landowners that own the beach can't even find a place to put their own chairs. You heard that testimony earlier because of the sheer number of tourists here. That creates problems. If I own the beach, I want to sit on it. Do I mind other people using it when I'm not? No. But when I want to use it, I would like to use it. Okay? And now you've got the tourists, these 4 million tourists, many of which, not all of them, because I don't want to categorize all of them, but a lot of them are coming down here spending a lot of money. We heard other people say that. Thousands of dollars to stay on the beach. They've been advertised that these beaches are open to the public. They feel entitled. So they come down here, they bring their tents, their chairs, every boom boxes, everything, and they don't feel like anybody can tell them what to do because they're spending thousands of dollars to come down and visit. And you've got tourists coming from Tennessee, Alabama, Georgia, the Carolinas, everywhere. I think the TDC is now going up to Chicago and other places, and paying millions of dollars to expand that base of advertisement to come visit Walton County. But there's got to be a sweet spot. There's got to be an equilibrium for this. You can't continue to grow the tourism numbers when you don't have the infrastructure to support it. We all like Walton County the way it is. It's quaint. 30A is a beautiful area. Do we want a 4-lane 30A? I submit everybody in this room would scream if the board proposed that. But it's not going to be long if you keep increasing tourists from 4 million to 5 million next year to 6 million the next year. Where does it stop? And then what is the implication of that? If you sell 200,000 tickets to a football stadium that can only hold 100,000 people, 100,000 people are going to be unhappy because they didn't get a seat. The other 100,000 are going to be unhappy because the other 100,000 were arguing about whether or not they had a seat. So you got 200,000 people unhappy because they're over congested. And so now, Walton County, the same thing applies. You're bringing 4 million people in when you have the infrastructure that would provide a wonderful, great experience for, say, 2 million people. So instead of having a situation where you've got 2 million people that are leaving happy and will come back all the time, you're trying to pack 4 million in here. And why are you trying to pack 4 million? Mr. Ufeller said it earlier. The almighty dollar, tax dollars. It keeps going up. Every time we get more beds, heads in beds, the tax dollar gets up. Y'all have more money to spend. But that's not always the best thing. Bigger's not always better. Would you rather have 4 million people that are unhappy, say, I'm never going back to that place again, it's too congested, can't get on the road, can't drive, can't use the beach? Or would you rather have the tax money that comes with 2 million people that's having a glorious experience down here? So I submit to you that the board and the commission needs to figure out what the real problem is, and that's overcrowding. Figure out where the sweet spot is. It might be 1 million, it might be 4, it might be 3, it might be 2, I don't know. But the trajectory we're going on now, customary use does not solve the problem. The beach is only so big. In fact, customary use is just a symptom of the real problem, which is overcrowding. And so, you adopt customary use, then the TDC, and I'm not trying to disparage TDC here, because they're doing their job. They did what y'all told them to go do. Bring tourists in, raise tax dollars, and they're doing it. The problem is, y'all have to tell them, we need to stop. This is the carrying capacity of our community until more infrastructure is in place. And again, I don't know if that's 2 million, 3 or 4 or what, but somebody needs to study that and figure it out. And so, if customary use is adopted, what happens? Now you're going to be advertising all over your website, the TDC. Beaches are open, customary use for everybody. Come on in. Now it's not going to be 4 million, it's going to be 8 million. What happens then? Now you got 8 million people that come down there and say, that place is way too crowded. The heck with that, we're not going back. 8 million people don't want anything to do with the beach. Before long, the word is spread, and now don't go to Walton County. It's too crowded, not a good experience. And the tourism is dead, the tax dollars are dead. And as the other speaker said, it's the goose. It's the goose that killed the golden egg. I think that's the statement. But anyhow, so you got to be careful, I think, of what you're doing here. And you got to look at what the real problem is. And I don't think adopting customary use solves the problem. I think it very well may exacerbate the very problem. So I'd encourage the county to go back to where we were before this customary use and conflict issues started occurring. Where were we at? 2009, 2.2 million, we didn't have this problem. It's only a problem now because tourism has doubled. Go back there. Don't adopt customary use, which will just perpetuate the problem. You'll end up spending millions of dollars. You've probably already spent $1 million on attorney's fees in the prior cases. As the prior speaker said, it's just going to be more litigation. It's going to be 10 years. Mr. Ufelder said 3 years before we get to the U.S. Supreme Court. It'll be probably 8 before we get there. We've got Circuit Court, District Court of Appeal, Florida Supreme Court, U.S. Supreme Court. It's at least 8 years of litigation. And assuming $1 million a year. It's a lot of money. Anyhow, so I'd encourage you to look at alternatives. And I know people have submitted some alternatives to the commission for them to consider, such as the Beach Share program. And that program is a voluntary program by beachfront owners that would put their property or allow the public to use their property subject to reasonable regulations of the public for some kind of compensation, whether it be lower taxes or whether it be a payment from the TDC, which is bringing in millions of dollars from all of these tourists, or something of that nature. But there's compromises out here, I think, that can be reached. We just have to get creative. But in the end, customary use, even if you pass it, I think ultimately, in a few years, tourism is going to die because of it, not increase. Thank you.
Please.
Thank you, Mr. Chair and members of the Commission and Council. My name is David Pleat from the law firm of Pleat & Perry. I'm a longtime resident along with my family of South Walton, also practice here in South Walton predominantly. I'm here on behalf of multiple owners of beachfront property. Previously, I've submitted objection letters on their behalf with parcel ID numbers, and I ask that they be made part of the record, as have previous counsel.
So moved.
Thank you. I'm here to discuss many misconceptions about House Bill 631, which has now been codified in Florida Statutes 163.05. This statute is a result of concern of private property owners over the lack of input and due process in the process of customary use trying to be established by the county. After 2016, when the first version of the ordinance was passed, one of my clients, Rosemary Beach Property Owners Association, filed a lawsuit against the county, not for money, but simply to ask the court for a declaratory judgment to declare that they had a right to a trial, to be heard and to defend in regard to rights being asserted through the ordinance by the county that they have a use for the public on their private property. That matter litigated and continued. It was based upon existing case law, which established, and I'm quoting from the Reynolds versus County of Volusia case, the doctrine of customary use requires the courts to ascertain in each case the degree of customary and ancient use the beach has been subject to. Based upon that, the case proceeded until such time as this statute, Florida Statute 163.05, was established. It established exactly what my client at the time was asking, a fair day in court, no more and no less. As a result of the passage of this statute, that particular piece of litigation was dismissed because it was no longer needed. My client would now, by statute, along with all the other property owners on the beach who wish to proceed, could actually have a day in court and defend. It is important to know that this statute simply does one thing, puts everybody on an even playing field. Anybody who owns a piece of property who had somebody else saying, I have some asserted use that I believe I have some right to your property, would have to file a lawsuit to prove that, and you'd have an opportunity to defend that. That's how our civil justice system works. What the ordinance did, it did away with that due process and said the county declares customary use and you don't have a right to defend. The statute allows that equal playing field. I submit also that this statute, this particular customary use statute, does not have within it a statute of limitations. You do not have to move forward today. It does not say you lose the right as a municipality to seek customary use as a doctrine imposed on the beaches at any time. And I ask you to do that because there are alternatives that have been discussed in part by others here today that are available, that are far less expensive, far less dividing of the community. The first is the purchase and acquisition of beachfront parcels and also access points to the beach. Both sides, I think, agree that that is a good path to take and to continue to provide outright public ownership of beach for those interested. The county can also continue to do a better job educating as to where public beaches are located for the county and the access points to those beaches. I'll give you a prime example. There's a Spooky Lane county access point on the side of Spooky Lane. Most people don't know that. It's hard to find, it's hard to get to. Here's what's even more interesting. I represented a property owner who had a beachfront parcel next to that access point on the beach. In the title search on that property, discovered that there is a large swath of beach in front of this parcel on the beach that's owned by Walton County. My client was aware of that when he decided to move forward and build on it. He wanted to get an 18-inch variance on his setback from the county, and in exchange, on his property at his dime, was going to build more parking spaces, restrooms, and other facilities to help better access and use of that beach parcel. Regrettably, that was denied by the county. So public education of where they can go, both state and county areas of the beach, would be a very wise way to proceed. And finally, the other way to proceed, absent of going forward with this litigation, is to reach out to the private property owners on the beach. That is a way to include them in a process of problem solving related to the density issues that have been outlined already by other counsel. Instead of making them adversaries, bring them and fold them into the process. You have over 1,000 beachfront owners. They are not all thinking like one single monolith. You might find ideas and solutions from different property owners that you didn't know existed because you forced this process to proceed. I would wrap up by saying that the decision to go forward is an expensive and a dangerous gambit for this county. If you go forward with the customary use litigation and the filing of this lawsuit, you risk the possibility of losing. Of course, I respect the fact the county feels its case is strong and will have a burden of proof when it comes time to trial. If you fail and you go through all the appellate processes and a court determines that the 26 miles of Walton County are not customary use beaches or subject to the customary use doctrine, that's it. That's it for all time. That will be precedent moving forward. If you win in that case, you will likely be subject, the county would likely be subject to a large amount of lawsuits over compensation issues related to the successful outcome of that customary use pursuit. So either way, it is a risky and expensive venture for this county. On behalf of my clients, I ask that you not move forward today with a vote, and if you do move forward, that you vote not to proceed with the filing of the lawsuit as per Florida Statutes 16305.
Thank you. Mr. Smoker.
Got to watch out for those steps. Mr. Chairman and members of the commission, my name is David Smolker. I'm with the Smolker Bartlett Law Firm, Tampa, Florida. We're here on behalf of the owners of 43 separate beachfront parcels of land within Walton County. We previously submitted 2 letters of objection, one prior to the September 8th hearing, and we submitted another one last week prior to this hearing. We'd ask that they be made part of the record.
So moved. So moved on that.
Thank you, Mr. Chairman. Can everyone hear me? All right, good. Additionally, Governor Haley Barbour has sent a letter of objection. He asked us to send it in to the commission, which we did. We'd like to make sure that that's made part of the record as well.
Just let I forwarded my copy to legal.
Okay.
And it'll be part of the record.
Very good, thank you. I've been asked to talk a little bit about why HB 631 was passed. And in order to do that, I need to give you sort of a little bit of Constitutional Law 101. Because there's a false narrative going around that somehow customary use is already established in Walton County. And that is a false narrative. First of all, only a court of law can establish the existence of customary use. No public interest group, No county commission, no individual can establish customary use. It can only be established by a court of law. And it is without dispute that no court of law has established customary use within Walton County. So we can't go around pretending that it already exists, because it does not exist as a matter of law. And we are a nation of laws. We follow the law. We don't follow it when we want to and ignore it when we don't. Now, since customary use has not been established as a matter of law in Walton County, when the county commission adopted their ordinance, they essentially were thumbing their nose at the judiciary's responsibility. And that was a big issue. And it was an issue that we should all be concerned about, because county commissions have broad home rule power, but it's not as broad as Mr. Theriak contends it is. You cannot pass laws that are inconsistent with the Constitution of the state of Florida. And the Constitution of the state of Florida separates the powers of government, and it gives the courts the power to declare customary use. It does not give county commissions. And that is why the legislature passed HB 631, because they knew what the Constitution said, and they knew that this ordinance was inconsistent with and violated that fundamental constitutional principle. Now, another important point about why HB 631 was adopted is that what the ordinance did was to authorize the physical invasion of private property by the public, plain and simple. The U.S. Supreme Court has made clear that such regulation by a government is what's called a per se taking, meaning the mere fact that you authorize the invasion of private property by the public is an instantaneous taking. We don't have to look at anything else. So here we are. HB 631 was passed specifically to ensure that the law was followed properly. Now, you do have the ability to bring a lawsuit and seek to declare customary use. And that's indisputable that you have the ability to bring a lawsuit. Now, there are some defenses to your ability to bring the lawsuit, because you've rolled out the red carpet over the years into private property owners who have justifiably relied upon a wide variety of county actions in buying their properties, in paying premiums for those properties, in paying premiums for their taxes on those properties, and now you want to pull the rug out from underneath them. That's not fair. That's just not the right way to do things. Now, the thing that is ultimately, to me, the most troubling about this process is that you have the ability and the power to do it the right way. It's very simple. Do a proper plan under Chapter 163 Florida statutes. You haven't done that. The lack of planning that is ultimately present here is really very stunning. I mean, you went out, you charged your Tourist Development Council with the job of bringing tourists to the Emerald Beaches, and you've done a fantastic job, and the beaches are great. But along with that effort to attract the public comes a responsibility to deal with them once they get here, and that you haven't done. You need to do an adequate study. You need to figure out what the carrying capacity is that you're willing to accept. You need to identify the properties that need to be acquired. You need to do a fiscal plan to figure out how much it's going to cost, and then you need to come up with a dedicated revenue source and a capital improvements plan and implement it over a period of years so that you can provide adequate facilities, public facilities, to accommodate public use of the beaches. That hasn't happened. And it's a significant failure. And it's really part of what's driving this whole exercise, is a failure to adequately plan in advance. Now, I can't lay that at this particular county commission's feet, but I can lay it at the county's feet. It needs to be addressed. And I think I've still got a little bit more time left. What I'm suggesting to you, ladies and gentlemen, is the way you're going about doing it is really the worst possible way of going about doing it. because you're creating a situation in which there's going to be winners and losers. And it's just not fair to be taking taxpayer money and essentially wielding it against your own citizens who've relied on your past actions. And I would think I would like to close with a quote. And this is from Oliver Wendell Holmes, famous U.S. Supreme Court Justice. He said, quote, "We are in danger of forgetting that a strong public desire to improve the public condition is not enough to warrant achieving the desire by a shorter cut than the constitutional way of paying for the change." However you want to slice this problem, the proper constitutional way of dealing with it is not to go forward and attempt to establish customary use. That is the most unfair approach you could possibly take. So with that, I would close. I would note that I didn't use all 10 minutes.
So noted.
And finally, what we would ask, Mr. Chairman, is one, don't vote to go forward with a customary use litigation. There's a better way to do it, accomplish the same objective. And if you do decide to go forward, we would respectfully request that you delete from the notice the various individual parcels that are identified in the letters that we've sent to you. Thank you for your time.
Thank you. All right. Let's see. Mary Grace, I believe you're up. All right. You have 10 minutes.
Mary Grace Rahm, R-A-H-M, Clark Partington Attorneys, Destin, 4100 Legendary Drive. Should the board decide to adopt the notice of intent today and initiate suit, the litigation that would ensue would be costly, complicated, and time-consuming, likely taking years to fully resolve. Thus, before moving forward, it is critical for the board to not only examine the strength of its case, but also consider exactly what a successful judicial establishment of customary use would offer the citizens of Walton County. The beachfront property in Walton County spans 26 miles. As illustrated in the chart provided by Walton County GIS, 16 miles are owned by beachfront property owners. But further review should be given to the western 4.5 miles of Walton County beach. These 4.5 miles are considered private beach, yet, as Mr. Matthews previously noted, as a result of beach nourishment, have an established erosion control line. As Mr. Dunaway mentioned earlier, there is no justification to seek customary use on areas of beach where an ECL has been established, as the public already has a right to use the sandy beach seaward of the ECL. Taking into consideration this additional 4.5 miles, private property with an ECL, that's more than 14.5 miles or 50% of Walton County's beach that's presently available for use by the public. The actions that this board contemplates taking today will have no effect on the public's ability to enjoy these more than 14 miles of beach. The public will always be able to continue using these beaches. In addition, our research suggests that the county has not considered those sections of private beach that have been dedicated for use by the public through subdivision plats. The plats of every subdivision in Walton County, including those with beachfront properties, had to be approved by the Board of County Commissioners that governed at the time it was created. These plats contain a dedication section, and the legal rights these dedication sections provide to the public vary for each subdivision. For example, as Dr. Miller testified earlier, the developers of Seagrove subdivision dedicated all of Seagrove's sandy beach to the public for use as a park, a dedication that the predecessors of this board thoughtfully approved. Despite knowing how to dedicate the beach to the public, through these plats, Walton County did not require that each subdivision make such a dedication. In fact, predecessors of this board routinely approved subdivision plats similar to those for Paradise by the Sea and Vizcaya, where the beach was expressly reserved to private property owners. The signatures of approval from prior board members exist on these plats right next to the language which explicitly states, "This dedication shall not create any rights of the public in property shown on the plat." Commissioners, I recognize that a majority of these plats and the dedications they contain were approved by prior boards. However, this board has a duty to its citizens to ensure that it is aware of all areas of beach in Walton County that are currently available for public use right now. While the Seagrove subdivision clearly makes its beach available for public use, the Seagrove Beach public property is not designated as public in the data provided by the county. Further research in these plats is necessary to uncover all of those areas of beach already available, because efforts to establish customary use on these properties would be wasteful and unnecessary. At best, what the county contemplates doing here today is taking a procedural step towards customary use on only 11.5 miles of beach in Walton County. In lieu of taking the time to educate the public about the accesses and beach presently available for use, the county has spent considerable time, efforts, and taxpayer money on the possibility of establishing customary use on only 11 miles, less than half of the beach, which prior boards of this county already approved as private. One area of concern where the county can direct its attention is beach access. Walton County offers more than 50 beach access points. Only 8 of these are regional beach accesses, meaning only 8 include parking and restrooms. The remaining 47 are neighborhood beach accesses, meaning they are primarily for walk-up traffic and contain no parking or restrooms. Successfully establishing customary use will provide no additional parking or beach access. The county should consider whether it is reasonable to invest time and resources into customary use litigation when resources may be better served by maintaining and expanding greatly needed access points. Walton County continues to purchase private property for access and use by the public. Since 2016, the county has spent over $10 million purchasing private beach property along Walton County for use. One issue the court will have to determine as it relates to the reasonableness of the use asserted is why would the county purchase these properties for use by the public if customary use already existed on them? Another issue that the county will face with respect to reasonableness of the use asserted is the issue of commercial vendors. Sizable sections of all county-maintained public beaches in Walton County that would otherwise be available for use by beachgoers are allocated by the county for commercial vendor use. While the services that these vendors provide are enjoyed by many visitors and residents, beach chairs often remain vacant and serve only to deplete sections of valuable beach property that could otherwise be used by the public. The board and the TDC have a history of regulating the vendors' use of Walton County beaches, and the county will have to prove to the court that the public use of private beach is reasonable, while 50% of county-maintained public beach is covered in vacant beach chairs. Commissioners, this hearing is designed to provide you with the information necessary for you to make an informed decision about how and whether to proceed. Myself and the 5 attorneys who spoke before me are here today to point out just some of the obstacles that stand in the way of the county successfully establishing customary use. In adopting the formal notice of intent today, the board would be leading Walton County down a litigious, costly, and ultimately unsuccessful path. The evidence is simply insufficient to establish that the use of Walton County beaches has been ancient, reasonable, without interruption, and free from dispute. and we ask that the board refrain from adopting the formal notice of intent today. Thank you for your time.
Thank you. Okay, that concludes all the attorney comments. Sid, I think you're next up.
Commissioners, so now we're at the section of the agenda for you to consider adoption of the formal notice of intent. The draft notice of intent was published on the county website. I am going to read it though for you and briefly summarize exhibits A and B that are referenced in the notice of intent. Pursuant to section 163.035, subparagraph 3, Florida statutes, the Board of County Commissioners for Walton County, Florida, hereby adopts a formal notice of intent to affirm the existence of recreational customary uses on certain properties in Walton County, Florida. Paragraph 1. The specific parcels of property upon which a customary use affirmation is sought are listed on Exhibit A, which is attached hereto and incorporated herein by reference. A customary use affirmation is sought only on the portion of the properties referenced in Exhibit A that consists of the dry sand area of the beach. The dry sand area of the beach is defined as the zone of unconsolidated material that extends landward from the mean high water line to the place where there is a marked change in material or physiographic form, or to the line of permanent vegetation, usually the effective limit of storm waves, whichever is more seaward. You all have a copy of Exhibit A. Exhibit A, for the audience, is a list of all beachfront parcels in Walton County, excluding the state parks, and there are a total of 1,195 parcels. Paragraph 2. The detailed, specific, and individual uses of the parcels of property to which a customary use affirmation is sought are as follows: traversing the beach, sitting on the sand, in a beach chair, or on a beach towel or blanket, using a beach umbrella that is 7 feet or less in diameter, sunbathing, picnicking, fishing, swimming, or surfing off the beach, placement of surfing or fishing equipment, and building sand creations. And that language was taken from the customary use ordinance that was adopted by this board. Paragraph 3. The sources of evidence that the County Commission would rely upon to prove a recreational customary use has been ancient, reasonable, without interruption, and free from dispute are listed on Exhibit B, which is attached hereto and incorporated herein by reference. In Exhibit B, this is the information that Mr. Theriak detailed at the beginning of his presentation. That includes all of the materials relied upon by Dr. Miller in his research, the expert testimony of Dr. Miller, testimony of residents of Walton County, testimony of visitors to Walton County, affidavits of residents of Walton County, affidavits of visitors to Walton County, pictures provided by residents of Walton County, pictures provided by visitors to Walton County, minutes of meetings held by the Walton County Board of County Commissioners, ordinances adopted by the Walton County Board of County Commissioners, emails sent to Walton County at the Beach Issues email address, development records in the custody of the Walton County Planning Department, plats, deeds, easements, agreements, orders, or other documents filed in the official records of Walton County, and the transcript of the Walton County Board of County Commissioners meeting held on September 8th, 2018. And that's the formal notice of intent.
Okay, thank you. What's the board's wishes?
Mr. Chairman, if I could make a motion that this board said if this went on, I would like to make a motion if the Board of County Commissioners in Walton County would adopt the formal notice of intent. Second.
Got a motion and a second. I'm going to take a roll call vote, so start the list. Commissioner Commander?
Yes.
Commissioner Nipper?
Yes.
Commissioner Jones? Commissioner Anderson? Yes. Chapman votes yes. Okay, I think that takes care of all that. Motion to adjourn. We are adjourned.